I would like to mention one matter, my lord, relating to pensionary benefits, my lord. The matter was listed on 13.3, and your lordship was pleased, my lord, to dictate the matter for disposal. But at that point of time, only one small point was required to be clarified.
Which one?
Pension matter, my lord, WPC 4789.
Hmm?
WPC 4789, my lord. And,
Under?
my lord,
Under what case?
my lord, pension matter, my lord.
Under which one?
My lord, on 13, my lord, on 13.3, it was taken up as the last item on my lord prayer, my lord. And your lordship was pleased to, my lord, dictate that disposal order. The instructions were ready, they were also present, other side, standing counsel AG. But later, at the last moment, my lord, only one small point was required to be clarified, my lord. So your lordship was pleased, my lord, to list the matter again on next deport, is at 2. But at 2, my lord, the matter could not be taken up.
Oh.
So, my lord, very urgent matter, the petitioner is suffering, he is now in hospital. So matter may kindly be taken tomorrow. It will take only 5 minutes. Obliged, highly obliged.
At 2.
My lord.
Tomorrow, Mr. Counsel, you mention the matter. I'm giving it. Tomorrow, mention the matter for upgrading.
May I please, Lordship? I petition item number 10, Lordship. Senior counsel out of session, Lordship. The Ukraine Nair sir and PK Goswami inform both are inform engaged counsel.
You want an adjournment?
Yes, Lordship.
You have informed the other side.
Yes, respondent.
We'll have it after 4 weeks. This is the matter at the request of the learned counsel for the petition after 4 weeks. Next.
My lord, this matter relates to my lord, some service benefit, my lord. They are not getting regular salary. The petitioner is suffering for that. And this matter on 22nd February matter was listed before the Honorable Justice Sumit Soikia. And there was an IA was filed to implead one official, and the IA was allowed, but the notice, the order sheet disclosed that the order is in is another nature, and appearance of shown of other lawyer, not of us.
I think you mentioned it before, Justice. Today he is not sitting, but I think tomorrow he may sit. Just mention it before him.
But I beg to mention this matter, my lord. After motion, my lord, it has not been listed.
Motion?
On last 1 year, my lord, it has not been.
It's a motion matter.
No, not motion. After
What matter?
motion, it has for admission. It has not been listed. Next week, any day, man.
Next week, no time. We'll have it on 10th of April.
I beg to mention for listing my lord, matter relates to non-payment of pension matter. Next week.
No
Please.
time. 12th of April. Last week.
With regard to item number 6, my lord, the matter has become infructuous. The matter has become infructuous, my lord.
The learned counsel, Mr. KKD. No.
PK Borua.
Your name is there.
My name is on
Where is
behalf of
Mr. KKD?
On behalf of Mr. KKD.
Where is he?
Lord, he is not present. Lord, he is not present.
Where is he?
But he is there in the town, but
Huh?
he is not present in the court today. I'm on his behalf.
E. Sharma?
He is no longer with us.
Mr. Counsel, I can very well say, make it infructuous and dismiss it. No problem with that. But the problem is tomorrow, if something happens, these people may take you to bar council. You get to understand the point. You want to show us particular document for which it is infructuous, this court will particularly say that it is. Why you are saying it to be infructuous?
The petitioner has got the relief matter.
Oh, now,
According to our instruction.
Mr. V.K. Burua, the learned counsel appearing on behalf of the petitioner, had submitted that the petitioner have already got the relief as sought for in the writ petition. And as such, the petitioner does not want to press the writ petition. Taking into account the said submission by Mr. Burua, the matter stands dismissed as being infructuous, on being infructuous.
To mention for withdrawal, please listen to
শুনা পাইছে?
please, Your Lordship, I like to mention listing for withdrawal, Lordship. Please, the matter list on tomorrow.
For what? Withdraw.
Withdrawal, Lordship. Please, Your Lordship. Lordship, I like to mention for urgent listing of an IA. That is 807-2023. Lordship, there is a typographical mistake in the judgment passed by coordinated bench. There is a typographical mistake passed by coordinated bench, and it is very much urgent to
Did
correct.
this court make the mistake?
No, Lordship.
I think you mentioned it before that court. Because I can't give, correct it, na? You mentioned it before that. Next,
Next. That's why I beg to mention for dictating of it, but
listing of,
dictating of it for admission, Lordship.
why?
Signature has not dictated for.
What happened? Why do you want the listing?
Matter not.
Madam, we can't hear you.
This matter has not dictated for long, Lordship.
What is the matter about?
Petitioner for compassionate appointment.
Huh?
For compassionate appointment.
Compassionate appointment. I think you mentioned this matter tomorrow before the other court. Today, this court is only taking up some urgent matters. Compassionate appointment can wait for the day. You get to mention before that court. Huh?
Item number 1, 2, and 3 to be spoken to.
Mr. Arandas, see, these matters I've looked into it. Problem which arises is in 2012, there was a direction by the state to adopt the new pension policy by way of a resolution. 2015, you say that you have done it. Have you taken any resolution?
Lordship, I don't think so, because Lordship, what happened?
How will the rules of 1969 or the amendment made to the rules of 1969 by the 2011 Act be applied to the 6th schedule areas?
Lordship, actually, thing is that in especially in North Kachar Hills as well as in Karbi Anglong Autonomous Council, there are two sectors of employees. One is governed by the council sector and the other is governed by the state sector. The salaries of the state sector employees were being given by the state government, and they were followed by the state government rules as per service procedure. But in council sector, Lordship, we don't have the provision of pension provision. Their salary employees are not entitled for pension.
Meaning thereby, they don't come under this act or that act also.
Lordship.
So irrespective, now in these cases, do they come within the ambit of it?
Lordship, in these cases, the petitioners were all, although they were absorbed by the North Kachar Hills Autonomous Council, they were treated as their council employee. But later on, with the rises of the vacancy, means in the state sector, they were being absorbed, Lordship.
To the state sector.
To the state sector. And their
But that
service
happened after 2005.
Lordship, prior to 2005.
Have you filed an affidavit in that?
Lordship, we have
filed?
Lordship, we have filed on 11/3/22.
In which case you have filed?
Lordship, 5409 of 20.
5409. In fact, the judgment is only waiting for this. Otherwise, I have already dictated. Finished.
Lordship,
Yes, where is that?
Lordship, third para, Lordship.
On 23rd of September? No,
No, Lordship, 11 March, Lordship.
11 March, there is no affidavit we have.
11 March 23, Lordship. I have the copy, Lordship.
5409.
5409. We have
There's no
already filed.
affidavit here.
It is on the record, Lordship. It's showing it.
Is it going?
54.
Here we have an affidavit in opposition filed by respondent number 3 on 26/7/2021.
No.
Affidavit in opposition filed by respondent number 7 on 23/9/2021.
This is
These are
an
the two
affidavit in
documents we are having.
additional affidavit in opposition filed by respondent number 6, Lordship. I have the copy, Lordship.
Madam, have you got a copy of it?
Lordship.
Why is it not on record?
But Lordship, since it is,
Lordship, I have the copy, Lordship. If
this
you want to-
affidavits are filed after result, the consent to recap, Lordship, I could not file it with like.
It was filed after the judgment was
Yes,
reserved.
Lordship.
Ah, that is the reason why the file is with me. How will it give it to me?
Lordship. Paragraph 3, Lordship.
No, no. But they are the North Kachar Hills person are entitled to the GPF.
Lordship.
They are entitled to the GPF
GPA.
initially,
Lordship.
as per the 1939. That you have adopted.
Lordship.
But for the purpose of 69 rules, you have not adopted.
No. As well as in Karbi Anglong also.
Now, where is your statement out here that the petitioners come under the normal sector?
Lordship, in the affidavit which we have filed on this one, affidavit we have filed on 26/7/21 by respondent number 3, paragraph 4, Lordship.
Yes, madam, what do you say this?
Lordship, your services were regularized against the government post, not under the Lordship. They are categorized as council post and government post. They were initially appointed under the council for last 30 years.
But do you admit to the fact that the council doesn't have the 1969 rules? Were you entitled when you were in the council?
Under the council, they were not eligible for pension. There was no pension.
Now thereupon,
Thereafter,
they were
regularized.
brought into the service of the government.
Government. And with the regulation, Lordship, they become entitled to pension.
Regularization where? Is it a case of regularization or a fresh appointment?
Regulation, Lordship. It is in their affidavit.
No.
itself.
Whether your appointment was irregular.
No, Lordship. Since it was under the council, and in their affidavit, they have stated that it was against the post sanctioned by the council, not against by the government, Lordship, by the council.
Let us see your regularization order.
Is Lordship 32 onwards.
Hmm?
32 page. Annexus C. Regularization of the senior most serving under non-pension post to the government pension post. In this regulation, they have not stated that the petitioner would not be entitled to any pension or they would come under the.
But were you not brought to the government service for the first time?
Regularized under to the government service.
No, therefore, whatever word these departments use, they don't actually do know. Yeah, upon seeing all these affidavits, they don't actually know what is the term regularization. But you were for the first time brought to the government service. That is an admitted fact. Then if that be so, how can the earlier service be taken into account?
Because Lordship, the article, Lordship 6 schedule, it is a 6 schedule area, and as per the provisions of 6 schedule law, the council has the authority. The subject, primary education and secondary education is the subject matter of the council, and they have the authority to manage everything to do in regard to the service and the education regarding Lordship by the council. Therefore, they are regular employee under the council.
No, they may be regular under the council. There's no quarrel with that. I'm not saying. But for the first time, you have come under the government service.
Government.
So how can, for the purpose of government service, the period which was spent earlier can be taken into account? Because if that is being taken, there's no end to it. Because for the first time you entered into the government service in the year 2010 or whatever may be this order.
It is not a new appointment, Lordship. In the
2013.
government sector, it is not new appointment under government sector. And after 2005, they were regularized.
Understood, but
Yes, it is regularized.
tell me what a regularization in proper sense means. A thing which is irregular is being brought. That's regularization. Now, how can you say in this case, it's a case of pure regularization? No. It is more of a hybrid regularization. Meaning thereby you were brought to the government service for the first time.
First time, but Lordship, under the council also, they were paid regular scale of pay, revision of pay.
But
Under
if you see, madam, kindly look into another document in your thing. Kindly come to page 30.
Yes.
Here it has been shown that you have been given the ROP.
ROP, yes,
Very well. It has been shown it is permanent.
permanent.
And this document is as per the ROP 2010.
Yes.
Although you are entitled from 1/1/2006. Let us see the earlier document at page 29. This court finds it difficult to I think this is not a proper type copy of page 30. Because here, the date which have been mentioned is (1992) down below. Where is the original of this document?
Page 30, Lordship.
It can't be page 30
Page 30.
because page 30, the date is 1/7/2000 with effect from 1/1/2006.
Page 30 type copy.
But why this is mentioned about 1/3/1991?
Page 30 type copy is 29.
Huh?
29 is the type copy of page 30. Page 30 is the original one.
It can't be. Because here the scale of pay has been shown as 10385. Now, if we do it, take 29 is the type copy of 28.
20. Bidhan Mohanto Lordship. Page 30 Bidhan Mohanto. This is the original copy. And 29 is the type copy.
So why have you mentioned some other figures out here? Page 29 and 30 are completely different. Now let us see page 28.
Original one is 30 Lord. Maybe type.
It can't be 30.
It is wrongly typed.
Madam, if you say so, you have certified it. Should we make an inquiry and find out as to whether page 30 and page 29 are the same? You have certified it to be true copy. Is it true?
Yes.
It can't be. Now, page number 27 and 28. One Srimati Sadhana Kaur. Here, the status is substantive, but the nature of post is temporary.
Temporary.
So you don't come within the ambit of the second proviso to section 31, rule 31. So unless you come under rule 31, how can your past service be taken into account? Maybe regularization or whatever the words these people may use.
But their service were against section 4 created by the
This
council.
happened when? After 2005. This is your appointment letter.
Appointment letter, initial appointment is to Lordship, is 15. Page 15. Annexure A.
No, that was under the council.
Concept.
Subsequently, you were brought within the government
After
sector for
2005.
under the state government where the rules of 1969 apply.
After 2005.
Then what is your right?
But Lordship, their past service. Their past service. is
How can it be
considered-
taken? How can your past service be taken for subsequently because of they have used the word regularization? There can't be a question of past service be taken.
It is not press appointment. They have stated that it is regularization.
Understood,
The
but
order
isn't
itself-
it for the first time you are coming into the government service?
But under the sixth schedule, the council has the same authority as per along with the
No.
government.
You tell me that you come under the government service? Well and fine, but do you come under the government service prior to 2005? No,
Before 2005 council.
Matt?
Yes.
The other matter, same?
Yeah.
Yes, Mr. Padgiri.
Secondary.
Hmm?
Item number 1, madam.
Yes.
Secondary.
What is it? Same?
No, madam. Different, madam.
Different?
Different, madam.
Very
Under
well.
Borpeta district.
Huh?
Borpeta district. madam.
Which one? Dipali
Item number-
Chaudhary.
Dipali Chaudhary.
What is it? Tell me.
He was appointed on service on 23/5/2001 as secretary
23?
23/5/2001,
Okay.
and thereafter, my lord, he is
22/5/2001. You were appointed as a stipendary
stipendary,
in pursuance to an order of the court.
my lord.
Okay, then
And thereafter, my lord, gone to the basic training, my lord. After completion of basic training, my lord.
Hmm.
Uh,
You completed in 2009.
completed, no, my lord, I completed 2011. my lord.
Okay. 2011 you completed. Then,
Completed. And thereafter, my lord, regular pay scale health.
so this will come under the stipendary.
Stipend.
This is not a Dima Hasaw matter.
No, my
So Dima Hasaw matter is only one.
Lordship, one.
And also does it, since after the judgment is
So
just the
stipendary type, huh? It is.
affidavit
5368 is a stipend. This is a stipendary matter.
Stipend.
And we have only one Dima Hasaw matter.
Lordship.
but the,
Tell me. And about the other matter.
Item number 2, lord.
What is yeah.
Teacher.
Yeah. Now, government, here, no, main problem is caused by finance. Where is Mr. R. Barbuzari? Not there.
Yes, today it was present.
Where?
Otherwise, these two matters are stipendary teacher issue, right? 1 and 2.
Which one?
Item 1 and
No, what, this was initially shown as what you call Dima Hasaw matter, but one is Dima Hasaw, then the other is stipendary.
item.
But this one is not a stipendary. This is an OBB.
OBB.
You see, what is required out here is different. What have you filed your affidavits? Who has filed? The director.
Elementary.
Because here he is asking for something more, Mr. Bora. Kindly see his prayer. That is why I have taken this out.
Release their salaries from the date of their initial appointment. Release their salary from the date of.
Edita, Ako, after clearing the doubts on the part, after clearing certain doubts, the judgment is reserved. Yeah.
but the, demand of the, I like your affidavit because they have filed affidavit after the-
We have taken it now. Affidavit. I've reopened it and again closed it.
but the, their past service may be considered because it is again session was targeted by the master.
Yes, Mr. Bora,
My lord,
you see what they are asking for
my lord, here, my lord,
is for the salary from 99 to April 2018.
18, my lord.
That he's asking.
Well.
One, and the other is that the seniority from the date of the original appointment, that is 99, asking that thereby he is asking for retrospective regularization.
My lord.
The third is a consequence of this, that if it is given a retrospective regularization, then he will be entitled as per the old pension.
My lord.
I think this matter needs to be heard in detail in some
My
other,
lord. If required, we will.
because
file-
this is the getting of the old pension scheme is ancillary
My
to
lord.
the main aspect. The first is as regards an area salary for almost 20 years.
My lord.
And the second is as regards the
Seniority,
retrospective regulation. So we bring this thing out
My
from
lord.
the Economic Lekivo, heard Mr. H. Besbura, the learned counsel appearing on behalf of the petitioner. Mr. P.K. Bora appears on behalf of the Elementary Education Department. Mr. B. Gugoi appears on behalf of the Finance Department. Taking into account that the instant matter, taking into account the facts involved in the instant matter, this court deems it appropriate that the same matter needs to be segregated from the rest of the matters. Accordingly, list the matters separately for admission on immediately after Bihu.
Much. God bless.
Hey, I don't do 1, 2, it's not correct. Ali item number itu dimahasau is item number 1 and 2. Huh? Dimahasau tu betul lagi. Heard Ms. RDB, the learned counsel appearing on behalf of the petitioner. Mr. RM Das appears for the appears on behalf of the district council of Dimahasau. The instant matter was again taken up for consideration, taking into account that there is an additional affidavit in opposition filed by the Dimahasau District Council on 11/3/2023. The matter, upon hearing the matter, this court further reserves the matter for judgment along with the other writ petitions. Yes, Mr. Chaudhary.
Supplemental is item number 11, part heard.
Yes, you got it.
These are the two names. You know. So both are retired professors of GMCS, and they have otherwise consented.
Madam, do you need 3 persons?
No, I do not know. That's for your lordship's convenience. I have only suggested one name, the neurologist, as per your lordship's direction. Whatever your lordship's feels appropriate. Perhaps the pediatrician from my learned friends list could be brought on stake, and then that would be a complete committee, so that we don't have a
No,
confusion
you
later on.
have given one
Only a
person from
neurologist.
neuro,
That's right. That's
and he has also given a person, Dr. Ashok Kayal.
The name proposed by the petitioner side, my lord, he is a junior doctor, my lord, not a as much experience than the retired professor. So I leave it to your lordship. These are retired persons.
And the other is Dr. Abhinandan Das.
Lordship, he was the doctor who was taking care of the child, as per the case summary. So I am not sure if that
That
might
won't
be,
be proper.
that might not be proper, your lord. That is there on record, your lord.
Then, my lord,
Then you need to find out somebody else. You find out somebody competitive. We have his name.
Lordship, problem is that the moment you say the word legal, no one wants to come forward. That is a difficulty. And especially no one wants to go against the government.
Think about what is the remuneration for, whether the state government should fix or should we fix it. Just have a word with your person concerned. Because something needs to be fixed.
yes,
Apart from secretarial expenses.
my lord.
Like in arbitration, the arbitrator is given the liberty out here. But if we appoint a commission out here, something
Well,
has to be said, that how much could be. Fair thing which can be possible.
My lord. Lordship direct, my lord, they will pay otherwise. my lord.
No,
Not be
it
any
is not
problem.
the question. I don't know how much it is. Because this will take some time for them also for passing us, giving us.
Lordship may pay them perhaps an honorarium, not a regular this thing. These doctors, your lordship may perhaps not be able to meet their standards. Perhaps a token honorarium for having rendered their services to
Yes,
the
lump sum amount, my lord.
some honorarium that perhaps should suffice. And for doing
You,
such
both
work,
of you suggest on that.
Lordship, he would be the competent because he's the one who has to release the funds. I wouldn't want to open my
He-
mouth.
He is an NHM also.
Lordship, may I also perhaps inquire as to where your lordship might want to undertake the process? Because
Huh?
that
Yes.
where your lordship might want to
No,
identify.
they will, you will have a place.
That
Yeah.
we can arrange, madam.
Huh?
That also will arrange.
That
madam,
thing we
required.
will arrange. We will give that direction. But we get hold of a pediatrician.
My lord.
When? Next Tuesday. We'll finish on Tuesday next,
My lord, sir.
so that we can give almost 2 months
Sure.
time for them to submit the report.
Sure.
Mr. B. Gogoi, Ms. R. Chaudhary, R.S. Chaudhary, the learned counsel appearing on behalf of the petitioner, had submitted the name of Dr. Nobojyoti Bokotokui, who specializes in neurology. Mr. B. Gogoi also suggested two names. One is Dr. Ashok Nayak, who was a former professor of neurology, GMC. And the other is Dr. Abhinandan Das, former professor of pediatrics. It, however, appears from the records that Dr. Abhinandan Das was connected to the instant case, and as such,
He was the
this
HOD
court
at the time.
would not like to embarrass him by appointing him as one of the doctors, one of the specialized doctors for the purpose of ascertaining the question of negligence. Under such circumstances, Mr. B. Gogoi is, as well as Mrs. R. Chaudhary is directed to suggest a name of a doctor who specializes in pediatrics on the next date. Let the matter be listed on 29th?
29.
29th.
28, not 28.
Or
Tuesday or-
28th, 28th, no,
No?
30. 30?
Tuesday or Wednesday.
I don't know, 4 and 5 for admission.
Yes, Mr. Bormiya, what is the matter about?
May be good. My lord, this matter regarding overstay in service. Petitioner overstayed, my lord, then he was retired, my lord.
Overstay. Where? Which department?
My lord, he is a LP school teacher.
Elementary.
Elementary.
You're lucky. The elementary school teachers, the councils are not so, they don't object so much as the other finance and the higher education. So your objection is lucky, otherwise they keep on object. Yes, overstay.
My lord, he was supposed to be retired on 1/1/2018, my lord.
It-
But he, my lord,
And
was,
you stayed till
my lord, 29th, my lord, 3/2022, my lord.
20?
29th, 3/2022, my lord.
Very well. And as such, they are asking for the money.
Yes, my lord.
Yes, Mr. NJ Khatami. For the fact that I have stated that the elementary education council does not object much, don't object.
No, my lord. In fact, in this batch of revision, my lord, earlier occasion, my lord was placed to hard miss. Not an AG also, my lord.
No, no, AG is for
As
another
regards-
purpose,
as regards
because I
the-
think there is a necessity for
Yes,
issuance
madam.
of an office memorandum
Yes, madam.
for doing something.
Yes.
Like you have an office memorandum. That day I was looking into, there's an office memorandum for the purpose of suspension.
Yes.
So something needs to be done, because what is happening, you can't do anything with the petitioner, because the petitioner has already rendered the service, and on the basis that you have allowed it, nothing can be done.
My lord, in fact, my lord, in this petition, my lord, he doesn't annex the service book, my lord, to the petition.
Your lordship, my lord, already had gone through the service book, where my lord, my date of birth, date of retirement, nothing.
Yes, Mr. B. Kaushik produced it on the last
Yes.
occasion. I remember.
Yes.
There is an order to that effect. Yes. Counsel appearing has produced the service book of the petition. The same be retained till the next date.
In fact, service is what is with Mr. B. Kaushik. Him, my lord.
Me, my lord.
Huh?
With me, service book with me, my lord.
Then
Yes, sir. I'll produce that too, my lord.
two.
My lord.
Take it up at
My
two.
lord,
And what is the other petition?
same, my lord, connected, my lord, just, my lord.
How can it be connected?
Because, my lord, I filed that, my lord, for my lord, gratuity, my lord, literally, etc. my lord.
That has not been given.
Yes, my lord.
That has been not given because of overstay.
Yes, my lord.
So once you set aside the overstay, the other petition will be allowed.
My lord,
Very well.
My lord,
it is, my lord, connected matter may be taken.
my lord,
Good.
can it be possible taking on Tuesday? On Tuesday, my lord.
Tuesday, there are a lot of other matters. But
On-
here
on-
the
on Monday,
petitioner
my lord.
has been suffering for not getting his gratuity and all.
Yes, sir. Nothing to give, my lord.
Tomorrow, my lord.
Tomorrow you know the list. And these are matters which need not detain this court for the purpose of disposal.
A service book, your lord, you also remember it is blank, my lord, nothing there.
Yes, the service break was blank. That is, I
My
remember.
lord, my lord.
And Mr. B. Kaushik,
His
with
date is
his smile,
not there.
had submitted. Huh?
Date of birth is not there in the service book.
Date of birth is not.
Right.
You do one thing, try your luck to try to get it at 2.
My lord,
These matters needs to be disposed of.
my lord. My lord. Obliged.
Keep it.
I have a remaining portion of the judgment.
Number 31 and 32.
Yes, Mr. Pathak.
There are two petitions. If your lordship gives me the indulgence, can I just, I have made a list, my lord.
What is the matter about?
Later, my lord, I'm just giving, may I have the indulgence of giving this list? Otherwise,
So
What happened, my lord?
your service has been terminated.
my lord, the facts are like this, my lord. Initially, I'm giving a summary first, then I will come to only one page. Petitioners, 7 of them were selected for accounts assistants and office assistants in the petition of municipal court. Then that selection process was challenged. Then the petition was dismissed. Then in that dismissal order saying that now they will be paid the regular salary. After the dismissal, we were not paid salary. We filed contempt petition. When the notice of the contempt was sent, then 3 of them out of 7 were terminated. The contempt petitioners, they were terminated from service. Then immediately thereafter, we filed a writ petition. Then there was a stay order regarding our termination, and we were reinstated. In the meantime, after reinstated, they gave a notice to us that take this 2 lakhs rupees each of you, 3 of you, not all of them, then please go. Then we again challenge. Then in the meantime, they have released some 1.9 lakh to us, but they have deprived us from regular salaries, which was fixed. Now we are getting monthly only 6,000. This is the crux of that. There's only those few, that few pages I have, only not few pages, only one page that disposes
No,
of the.
the interim order was passed in this petition,
In this petition,
whereby you were allowed to, the termination orders were stayed.
state, my lord, yes,
This petition.
yes, ma'am. My lord, that
Where is that order of
my
interim
lord
order?
will see. My lord, can I just refer to this, my lord? This will make me more easier for
Yes, 1 minute.
it's becoming a voluminous file.
Read that.
Page number 31.
Page number?
Page number 31.
31 is a part of the writ petition.
Yes,
Prayer.
madam. I am 590/2021, repetition number 590, that is the first time.
590.
Yes,
Yes.
page number 30,
590. Page number 31 is the prayer.
prayer, ma'am. That is the prayer.
The prayer is 31/12/2020.
Yes,
Now, where is that document?
that 31/12/2020. That is page 51. I'm just,
Yes, got it. Page
Yes.
95.
my lord, I'm sorry, obliged.
Okay. So you were temporarily appointed.
No, we are regularized. That's what I am coming, my lord.
Where is regular?
At page number 37, initially, our salary was given and consolidated. Page number 47.
Let's see first the appointment order.
Yeah, page number
37.
37.
The last municipal court.
This is the temporary appointment, contract basis. First is
Temporary basis. So on 16/4/2014, you were appointed on temporary basis.
temporary. Then your lordship will come to page number 47.
47.
Yes.
Okay.
Appointed again temporarily.
Temporarily again.
We
You
have
have
brought
been given the pay scale,
pay scale
but you continue to remain temporary.
along with all 7. 3 of them continued to remain temporarily. And initially we were 7 of us elected. Then because we filed the contempt and everything, the consequences followed. So this is the put.
So you were temporary.
I have even not been given this scale. I have not been given this scale, 6,000 rupees I have given.
Are you asking for the scale or the
Yes,
termination?
I am asking for the scale as well as the termination.
No, the prayer out here is what?
First is the
Terminating Iman and the impugned
Pay and
denial of
allowances.
lawful salary. So you are asking for the salary also.
salary also, because initially division bench, this high court said, that please pay, gave them the pay and salary. But when we were not getting it, we filed a contempt. That resulted as not termination. That resulted in the second writ petition, which was stayed, termination was stayed. Then we were reinstated with a package that take this 2 lakhs and go. Then we refused that. So at this stage, that matter is.
So are you working?
I'm working,
You have been reinstated.
my lord.
You have been reinstated on the basis of an interim order.
But salary we are not getting. Felix,
Yes.
I'm appealing for the municipal board lots. But yesterday we have filed one affidavit lots.
He is not having any difficulties. Do you have a difficulty?
No lots.
Then tell me.
The thing is that lots of in terms of the interim order, all the petitioner has resigned lots, and they are continuing in their service. Now in April 2022, the new board has taken charge of the PCMP lots. So in the affidavit, I'm placing the instruction of the resolution number 3 lots that the petitioners, in order to settle the disputes, also. It is a long pending issue, multiplicity of litigations are there. So in order to settle all these disputes, the petitioners, I have placed the instruction that petitioner may approach the new board with the force press representation, with renewing their prayer lots. And that will be in terms, I have categorically stated in the affidavit, that will be considered by the new board constituted in the last April 2022. Because as far as their prayer, they have already joined us. Only the salary part remains as on today. And one position of BCMB is very pathetic. The municipal board.
Your affidavit is not on the basis of that you don't have the fund
I have,
or justifying the termination order.
no, Lordship,
Are you justifying the termination order? or
no,
not?
no, I have to just place on record that in terms of the interim order, they have resigned, Lordship. The two parts of their prayer has already been sufficed, Lordship. The remaining part is the salary. The
So
salary.
that means you are not serious in going ahead with the termination order.
No, Lordship, as on today, termination, whatever instruction I have received, I have placed on record that they have resigned, they are continuing, they are getting the fixed salary of 6,000 per month as on today, Lordship. And regarding their salary and continuing in service without break, that will be considered by the new board, Lordship.
But your board have duly accepted their accepted that the
New
termination
board,
order is bad.
New board has Lordship in their affidavit, whatever
No,
instruction. I
no,
have
I'm
received.
saying only on the basis of affidavit. I'm not asking you to say from yourself. Yes, where is your affidavit?
Affidavit yesterday I have filed.
Today you have
It's on record.
affidavit filed by AR on 22/3.
Yes, that's
Got it. We have it nowadays. Let us see. Holding the post of the executive officer upon is stated while claiming the remand. Oh. Mr. Pathak,
Yes.
kindly come to page 214 now. Nowadays we have a running page.
Yes, 214, my lord.
Subparat Roman 2.
All the petitioners have resumed their respective petitions so and so by submitting the individual letters resuming duty, addressing. Yes, they have resumed. They are in fact.
No. Hence the effect of the orders. These are the termination orders. Automatically stands cancelled from 9/3/2022. So those orders have gone. You got your relief.
Only part really remains. I
And
missed
as
out.
regards the others,
Lordship.
he says that you want they should represent
Lordship.
and then you will take a call.
Lordship. The new body is in charge, Lordship, the elected body headed by the chairman. So on instruction from the new body, this deponent has submitted this affidavit. And they have received certain amount, Lordship. We have stated in paragraph Roman 3.
So they have received 3,95,000.
3 lakh,
Also into page number 60, my lord. Page number 60, your lordship will see. That was
3 lakh 14,093 as per our instruction, including this the 2.5%.
And who appears for the Director of Municipal Administration, Urban Development?
Municipal.
It's Urban Development Department.
Urban development is not a party, Lordship.
Yes, why you are not paying them?
Lordship, section 50, Lordship.
For what?
Here, the board has to manage, Lordship, section 50, Lordship, in terms of section 50 Lordship. We have no role in paying allowances
How does the board run?
from their own income, Lordship.
not
we-
from
we-
granting aids.
Municipal
We
fund.
grant aids lordship, but for
Are you
salary and
saying that
allowance,
the Assam Municipal Act overrides the constitution?
that's not lordship. We grant aids lordship, but there should be a proposal from the board lordship. Otherwise lordship.
And why you are not giving the proposal?
Lordship, as per my instruction, proposal were given.
And
That's
they are not taking
no,
anything?
Lordship. They're simply
See,
saying the tick plea of section.
Why you are not putting it to the finance commission?
That is not, like whether
Have you put it to the finance commission? You come under chapter 9A, na?
Lordship.
Chapter 9 and 9A or 9B? Constitution?
9A.
Mr. Das, you are appearing before this court without a constitution.
Lordship. I'm sorry.
You said
Section 58. There has to be a fund of the municipal board. And the state, among others, are also obliged to put a fund so that they can run their section 58 of the.
no, Mr. Parung, this is just this is done under the 56 Act.
56.
But you see, after the constitutional amendment, which had been brought in, by
Oh,
which
yes.
the municipal administrations were brought in, things have changed. Now they have been given a constitutional status like the panchayat. And as such, there are specific provisions by which it will be dealt with. If we look into chapter, yes, chapter 9B, not 9B, 9A. Yes, 9A. You see 9 in chapter 9A, more particularly, here you will see how the finances will be there. Duration, membership, so and so, power to impose taxes, finance commission, 2Y, 243Y. The finance commission constituted under 243(1) by the governor, by the governor, shall also review the financial positions of the municipalities and make recommendations to the governor as to the principles which should govern the distribution between the state and tax. And number 3, the granting aid to the municipalities from the consolidated fund.
I am okay.
Now,
Yes.
if you see further, Mr. Pato, kindly come to 280.
400.
280. How will this person, how will the finance commission of constituted under 243(1) will get it? It is given in 280 that the president will appoint a finance commission for the central, and this finance commission shall take into account the recommendation being made by the state finance commission for the purpose of giving the said amount to the finance commission to be given to the state so that they can give the grant in it. This is how it works. Okay.
Argument should have been at a much better level.
Hmm.
My argument should have been at a different level. I have failed in my duties today.
Something needs to be done. Anyway, that is another aspect of the matter. Mr. Roy should not be put into this. But if they represent, what is the course of action you are going to take? You may say that no, this we won't. No, we are not in a position to give you this money, that money. What happens to them then?
Lordship, already, although I have not brought in record the affidavit, the instruction that I have received, already a proposal was given to the petitioners that after the taking over charge of the new body since April 2022, they are ready to pay with the regular pay scale, Lordship. But and thereafter, Lordship, they will decide and they will take a call on the earlier dues, Lordship, remaining dues, the balance amount.
And
That-
what do they, what's the stand? No idea.
At the moment, they are getting 6,000. And I have also told my learned colleague that if, because in the affidavit, they say that there is a financial burden. At least immediately, if they are brought to the regular scale, which others are getting. So at least harm relief they will get. And regarding arrears, they have to file a representation if your lordship so direct. And let them
Then,
take a call.
Mr. Das, you do one thing, you put that instruction by on affidavit that you are ready to give a regular pay scale. And the remaining will be on the basis of they may represent and the board taking into account the financial exigency will do the need.
And in the meantime, Lordship, if they have come up with some other proposals also regarding the earlier.
I think that is a better option.
Lordship.
Heard Mr. KP Pathak, the senior counsel, assisted by A. Borua and Mr. D. Das
Lordship.
appears on behalf of
Respondent number 1, 3, and 4.
1, 2, 3, and 4.
1, 3, and 4.
Respondent numbers 2, 3, and 4.
1, 3, and 4.
1, 2. 1, 2, 3, and 4. Oh, government is not. Oh, no, 1, 3, and 4.
Lots.
Mr. S. Roy appears on SS Roy appears on behalf of the respondent number 2. Mr.
P. Bordel.
G. Bordley.
P. Bordel.
P. Bordley appears for whom?
In other case, I appeared for in item number.
For respondent number?
Respondent number.
3, Director of Municipal Administration.
Director of Municipal Administration, I am appearing.
And for whom he is appearing?
Chairman, I think.
Chairman, you are appearing him also.
Lordship, I have been recently engaged as a standing counsel. This is the previously pending case. That's why he is handling.
And what is your stand?
Lordship,
You are contesting.
Lordship, against a particular termination orders, Lordship, they were reinstated, Lordship, in that particular case, Lordship. So
That I have seen it from the affidavit.
Lordship,
Now questions, you were appointed by the earlier board
Lordship,
and as such you still continue.
Lordship, in that particular case, we appeared, Lordship. As a
Lordship,
caveat, Lordship.
he appeared for the salmon, D-Dan salmon, Lordship. And that issue is no longer there, Lordship.
What is this 14/6/2019 order? What order has been put to challenge? Termination.
Termination. That
This is another termination.
after the contempt, I was terminated.
They were reinstated.
They were reinstated in 31/12
No,
or
Lordship.
this order. There is no reinstatement on in under area reinstating the.
We are
people
not
and
reinstated,
respondent
yeah.
on the recalling of the order of termination.
2020.
Orders on further reinstating them in service with the resolution. No, there's an order of reinstatement on 14/10/2019.
Sir, it is in the additional affidavit, Lordship. Page number 72.
Therefore, the challenge which have been made on 14/6/2019 and 22/5/2019 has become infructuous in view of 14/10/2000 by which they haven't recalled. So we close this petition unnecessarily. At least do something useful in a day. We'll only keep the other one. Heard Mr. KP Pathak to our order to Usadu. Heard Mr. KP Pathak, the learned senior counsel, assisted by Mr. K. Bordel and Mr.
P. Bordel.
P. Bordel appears on behalf of the respondent numbers 1, 2, and 4. Mr. Estro appears on behalf of the respondent number 3. The instant writ petition was filed challenging the orders dated 14/6/2019 and 22/5/2019 passed by the respondent numbers 1, 2, and 4 It however appears on record that pursuant to those orders, by an order dated 14/10/2019, the petitioners were reinstated in service to their respective posts with effect from 16/10/2019. Considering the above, as well as the further developments which have led to the filing of WPC number 590/2021, nothing remains for adjudication in the instant writ petition, for which the instant writ petition stands closed as infructuous. Mr. K.P. Pathak, the learned senior counsel, assisted by Mr. A. Bulwa, Mr. D. Das, appears on behalf of the respondent numbers 1, 3, and 4, and Mr. S. S. Roy appears on behalf of the respondent number 2. The petitioner in the instant case have challenged the termination order dated 31/12/2020 from their respective posts under the Biswanath Sariali Municipal Board, as well as have also challenged the actions of the respondent board in not making payment of the lawful salary to which the petitioners are entitled to. It appears on records that by an order dated 8/2/2021, when the instant writ petition was taken up at the motion stage, this court, upon hearing the learned counsel as well as this court had stayed the impugned letters of termination dated 31/12/2020 until further orders. Further to that, it has been mentioned, it was directed that the respondent board shall also pay the amount of rupees 2,50,000 to each of the petitioners within 2 months from the date of receipt of the order as a one-time settlement offer had been made by letter dated 17/12/2020. It was observed that the said payment shall not cause prejudice to the petitioner's right to make a further claim of the alleged due. It appears that the pleadings have been exchanged. However, there has been a change of the constitution of the respondent board with effect from April 2022. The board presently, the present board, through its, who is this person?
Executive.
Through its executive officer, had filed an additional affidavit on 22/3/2023. In the said additional affidavit, it is the categorical stand of the respondent board that the orders, the impugned orders dated 31/12/2020 by which the petitioners were terminated stood automatically cancelled with effect from 9/3/2022. Under such circumstances, a part of the relief which had been sought for by the petitioner have already been given to them. The next question, the next aspect which arises is as regards the petition, as regards the salary to which the petitioners were entitled to have not been given. Inasmuch as it is the submission of the learned counsel, senior counsel appearing on behalf of the petitioners, that the petitioners are still getting a fixed pay of ₹6,000 per month. Mr. Didas, the learned counsel appearing on behalf of the respondent board, submits that as per his instructions, the board is willing to give the regular salary to the petitioner henceforth. And as regards the area salary, if the petitioner as regards the area salary, taking in, it would be, the petitioners may be given the liberty to submit a representation. And the respondent board shall take such decision, taking into account their financial exigency. Upon hearing this, the learned counsels for the parties, this court deems that the said instructions which have been submitted, the submissions made by Mr. Ditas, to the effect that that the respondent board henceforth would be giving the regular scale of pay to the petitioners. And there would be a consideration of the representation submitted as regards the area salary be put by way of an affidavit, so that this court can take up the matter for further consideration. How much time?
A week time.
Huh?
A week time will do.
We'll have it on 10th,
Lots.
11th. 11th?
Lots.
And the matter will be again listed on 11th for further consideration. In the meantime, the said affidavit would. What is this IA business? Huh?
I've not given a copy.
Copy not given. Or you were not allowed to resume duties. Now you're doing.
That may be closed.
I'm,
That may
we
be
are,
closed.
we are, no, yes, we are serving.
To be closed.
That's-
Mr. KP Pathak, the learned, heard Mr. KP Pathak, the learned senior counsel assisted by Mr. A. Borua, and Mr. Didas appears on behalf of the respondent numbers 1, 3, and 5, or 1, 3, and 4. And Mr. S. Roy appears on behalf of the respondent number 2. The learned counsel for the petition, senior counsel for the petitioner submits that in view of the present stand of the respondent board, and as the petitioner have present stand of the respondent board, as it emanates from the affidavit filed on 22/3/2023, and that the petitioner have now been allowed to resume their duties, he would not like to press the instant I interlocutory. Accordingly, the I stands.
May I please, Your Lordship?
Yes.
I beg to mention item number 26 and 30, that matter has been fixed on 2 o'clock. I'm appearing on behalf of Income Tax Department to file and counter affidavit.
You are appearing for
Income Tax Department,
which matter?
26 and 30 years.
Income tax matters, why?
Oh,
that series.
that series.
Yes, what affidavit you want?
We have to file our counter affidavit on that part.
That is a different thing. Mr. Kyle is also appearing.
He's also paying for another cases. I'm allocated for 26 and 30.
Yes, you want to bring it on record?
Yes.
Affidavit.
I need to know. I'm deeply aware.
But Mr. Gogoi, you are Mr. Gogoi?
Lordship,
Your name?
Dr. B.N. Gogoi,
Yeah.
26 and 30.
Understood. You should have mentioned the matter at not in the morning at 10:30. Why haven't you done that?
So there is a technical error. It's
Mr. Gogoi, Dr. Gogoi, let me tell you one thing. This court doesn't appreciate mentioning about the matter.
I am under circumstances. I beg to
So
apologize.
next time, kindly
Next time
clear it.
I will take care of it. I'm deeply aware.
Number 7 for hearing.
এইটো মেনশন কৰা নাই জানো? উইথড্ৰ কৰা নাই নেকি এইটো? এইটো নহয় জানো? এইটো নহয় 6 good. Yes, finance, nobody from finance, nobody from AFPC, nothing. I think nothing survives in the matter. Mention has been made by Mr. Lalit Patil has personal difficulty. It again, none appears for the Leave the matter for hearing. And keep the matter before any other bench. It again, and what is the matter? Let us see. The rate. Why nobody from the government is Mr. Roy? Any idea on this matter?
No, there's.
I think they must have forgotten neither the finance is there.
Council was there.
Okay. I was about to dismiss it.
All that. I just checked up.
Tell me.
Yes. Nothing the petitioner is your lordship. A registered association of employees of the AFPC. The Assam Fisheries Development Cooperative
Petitioner is a society or something.
Association of employees.
Then
Yes. We are aggrieved, the lordship, by annexure 1.
Yes.
It's a notification dated 7/6/2011. Yeah, second copy. The lordship, we fall under the subgroup C1 at page 12. At page 12, Your Honor.
tell me.
I'll first read out the impugned portion, Your Lordship.
The governor of Assam is pleased to order the revised pay band corresponding rate pay as recommended by the state labor enterprise. Yes.
Lordship, I do not have any copy of this. This is 2011 matter, Lordship.
That is the more necessity that the matter needs to be done. Does it look nice for a 2011 matter to be pending? We are in 2023. Just give me a justice.
I have to go to it.
I'm also going. You also go through it. Let him explain. I'm also. I don't look into the files earlier. I'm also looking. You also.
Yeah, we don't. We not aware of anything regarding this paper. And then
You are AFDC.
Lordship.
Let us see what you, because you see, granting an adjournment of a 2011 matter doesn't. Let us see whether he makes out the case. If he makes out the case, then I'll ask you. Then you reply. Otherwise, I don't disturb the respondent. Yes.
Yes, Your Lordship. The governor of Assam is pleased to order revised pay band with the corresponding grade pay as recommended by the State Level Public Enterprises Pay Revision Committee 2010 and further recommendations of the Cabinet Subcommittee
on revision of pay scales and applicable to the following SLPEs placed under category C, which are further subgrouped
What is
as
this SLP?
state level public enterprise.
Okay.
Your Lordship. Which are further subgrouped as C1 on the basis of criteria such that the accounts are unaudited, irrespective of whether they are making net profit or operating profit, as C2, which are loss making but can be strengthened, restructured, revived, and as C3, engaged in social and welfare activities, incurring continuous losses but cannot be closed down. SLPEs under
So
subgroup
you come under, this
Five.
one comes under
C1-5,
C1
C1-5.
on the basis that the accounts are unaudited irrespective of whether they are making net profit or operating profit.
Yes.
So further recommends that the cabinet of
Now, Your Lordship, the infringing part is the paragraph that follows.
the SLP mentioned in C1 above will be eligible to revise their pay structure as per the pay band to the revised rate as mentioned above. In case of pay band 1 and 2, based on the resolution of the anomaly committee issued by notification dated mentor, which shall be applicable once their account, annual accounts are audited to with the following notification and so this pay band will be given or the pay scale will be increased subject to audit.
Audit. Now, Your Lordship, this notification, it affects us because the employees, the petitioners before Your Lordship, they were receiving the revised pay scale as per the state government report. Thereafter, by this notification creates two classes, which I cannot go into, Your Lordship, because it's a policy decision. They've gone into state enterprise and state level public enterprise. That is fine. I have no grievance with that, Your Lordship. My grievance starts from the fact that my revised pay scale as per the state government employees have now gone back to what it earlier was, which is not at par with state government employees, primarily due to the reason that the accounts of the corporation has not been audited. The auditing of the accounts of the corporation is an obligation that falls on the MD. It falls on the AFD. Now, Your Lordship, I understand that judicial restraint is circumspect in terms of policy decision, Your Lordship, unless the same is vitiated.
So if the accounts are audited,
Yes, if the accounts are audited,
then you will get it.
yes,
Now therefore the case is
Yeah.
in a simple term
yes,
that you would have otherwise been entitled to,
I'm entitled.
but you have not been, you have been disentitled
disentitled.
at a thing which you have no
I do
control.
not have a control.
That's your case.
Yes, that is my only case, and Lordship, frankly,
Anything else? Anything else?
nothing else. That is the only prayer that I have.
See, matter pending from 2011. Now, as of now, whether AFBC has audited accounts or not, 100%.
We are paying recently, Lordship. There is some disciplinary proceedings against the officers of the AFDC also. In that case also, we are paying as per the government payment, Lordship. As per the government of Assam.
As of now, you are giving as per the 7th pay commission.
Lordship.
You are giving
ROP. So we are about to give, Lordship. We have just approved about some days ago, Lordship. It has been approved.
It has been approved as per the 7th pay commission.
Lordship.
You are going to give.
I
Earlier, did you give the 6th pay commission? This is, I think, 5th pay
This
commission.
is the fifth pay.
As per my
This 2010 is the 5th pay.
Yes, the fifth pay.
Is it so?
It's the seventh pay happened after.
No.
2017.
2010 is a 6th pay.
Sixth pay. 17 onwards, the seventh pay had come into effect.
7th. So 2010 is a
2010.
6th pay.
Yes, yes.
So you have thereafter given 6th pay.
Lordship.
As of now, are you giving 6th pay or not? If you are going to 7th pay, obviously you must have given 6th pay.
Lordship.
Get your instructions back to better than. No, Mr. Sharma.
Yes, sir.
Lordship, I can give you if Lordship give 2 minutes, I can.
Yes. No, you see,
Yeah.
you were deprived
Yeah.
at that point of time because you moved the matter in 2011.
Left.
Thereafter, you must have got the 6th pay, a 5th pay.
Yes, that pay will be further subject to the revision which is laid down here. Now, when my friend makes a submission that we are getting our current salary as per the state government employees, I cannot have an objection to that much.
No.
Yes.
Are you saying,
Yes, sir.
are you not asking for a mandamus
I'm asking for a mandamus.
to that effect, that a direction be given to the AFDC to go ahead with their audit?
Yes. That is not primarily the prayer in the writ petition, Your Lordship.
Then
The prayer in the writ petition primarily pertains to that
the
I-
challenge to that condition.
Yes. The
Why?
condition,
How can you challenge that condition?
because the condition will also challenge the condition on the fact that the condition does not have a nexus with the object or with the object that is sought to impose on the petitioner. Your Lordship. it is-
And another thing,
Yes, Your Lordship.
once the 6-pay commission, the 5-pay commission has been given,
Yes.
was it given from 1/1/2006 or from the date it is?
From the date, Your Lordship, I'll submit. In fact, we were not earlier getting the pay as per the state government employees. If Your Lordship can kindly come to,
Oh, it will be from, no, you'll be getting from 1/1/2011. It's there, number 4.
the pay structure shall take effect from 1/1/2011. Yes, Your Lordship.
So
Yes.
it has been given a retrospective effect. So once they have audited,
Yes,
then you'll be getting it retrospective from 1/1/2011.
but this is nowhere, Your Lordship. Yes, this says that this the revised pay structure shall take effect from 1/1/2011. But the fact that it will also entail my area salaries once the audit of the accounts take place, that has nowhere been clarified. Your Lordship. So once
No,
the
no,
audit
no,
of the
no, no.
accounts take place,
Just for example, let us assume this document.
yes, yes,
It was issued on 7/6/2011, saying that those people have to get it audited,
yes,
and unless you don't get it, you are not going to get it.
yes.
As of now, those people who had the audit,
If they have the audit, yes.
they would get it from 1/1/2011.
No, that is as per Your Lordship understanding, which I cannot dispute on, Your Lordship. Absolutely. In fact, that works to my advantage as a petitioner, Your Lordship. But this document, it fails to address the issue that Your Lordship had correctly stated now. That if the audit of the accounts take place, am I entitled to also the arrears when the audit of the account did not take? So this.
No. Your area will, that is what I'm saying, number
Yes,
4.
Yes,
Once the audit takes place,
yes, Your Lordship.
wouldn't you be entitled to from 1/1/2011
I should be.
in view of clause 4?
I should be. The
Because
previous
this is being given retrospective effect from 1/1/2000, because
Yes.
this was given in the month of June.
in the month of June.
Now, is it
Yes.
mentioned out here in any way
Yes,
that because of the audit being not done,
yes.
then it will be prospective as per this? From the date the audit has been done, is it mentioned here?
It has not been mentioned. It has
Then,
not been touched. This aspect has not been touched. Now,
so your instruction, therefore,
yes.
you are too jealous to move the matter immediately in 2011.
That-
Obviously, you didn't join the practice, I suppose. Or did you join?
I was clear for it.
Ah. So you didn't join, but there was a jealous, there was a overzealous on the part of the petitioners to move the matter immediately. But what has happened is, once the audit has been done,
Yeah.
wouldn't that go back to 1/1/2011?
In fact, Your Lordship, the observation is so pertinent that failed to establish contact with our client.
Huh?
That we had failed to establish any sort of contact with your clients, our clients, from 2012 onward. Maybe Your Lordship's understanding of the entire matter and how.
That is why they
how-
got it.
That can be.
He is retired lot. This petitioner.
Very well, but.
Whatever may be. You see, his specific case is a simple case. It's not a complicated. He said, look here, I'm entitled to a pay scale. Normally, the pay scale is extended. Now, here the pay scale has been extended subject to a entity having its audited accounts as on of 2009 and 10 being done. I have no control over it. And under such circumstances, this notification, this condition is onerous for him because he is going to get the money. But one problem which Mr. Sharma,
Yes.
this court has to deal with, the fact that without asking for a mandamus. Have you asked for a mandamus to do the complete the audit?
No.
Because what you should have done is ask for a mandamus, directing them to go for an audit. Because for doing an audit, you see, otherwise the notification you cannot fault it. The reason is, you see, the government says that yes, how can we direct these people to come up with a new pay scheme without auditing their accounts?
Without showing the profit and losses category.
Absolutely.
Your Lordship is absolutely correct.
So under such circumstances, this notification cannot be faulted with.
Unless we challenge the root cause.
So what is your relief should have been for a direction to the AFDC that they complete their, because you are not getting.
I'm not getting.
This is the other way around.
Yes.
But one thing, another very relevant aspect of the matter is that it says that the payment will be given from 1/1/2011.
Yes.
Although the other things have happened from 1/1/2006
Yes.
in respect to the 50 commission, but it has been extended in the case of these public sector enterprises from 1/1/2011.
Yes.
So you must have got those things. I give you, I'm coming, 10 minutes.
Okay.
Get your instructions. The most satisfaction this court gets is disposing of an old man.
Lordship,
Because you see, it doesn't look nice for a,
Lordship,
isn't this one of the most simple matters? You didn't look into the file, and then also this is the simplest
simple. As per 7
we are giving.
I think from 2001, every year audit is being done. Almost statutory auditor is also there, AZ also doing audit. Regarding one thing, Lordship, this petitioner actually is not getting any gratuity because he is involved in another this affidavit. The person who signed the affidavit, Tarini Deka, he was involved in recruitment scam, Lordship. So we are not paying the gratuity.
That is not the question here. Here he has filed the affidavit as a member of General Secretary of an
He
association.
was not, as of now, he is not there. He is retired.
Mr. M. Sharma, the legal counsel appearing on behalf of the petitioner, and Mr. P.
Sharma.
P. Sharma appears on behalf of the Assam Finance and Fisheries Development Corporation, and Mr. Asolia appears on behalf of the Finance Department. The instant writ petition has been filed by the Petition Association, which represents the employees working under the Assam Fisheries Development Corporation. The challenge in respect to the instant writ petition is to the notification dated 7/6/2011, whereby the Assam Services. What is that name?
Assam Fisheries Development.
Huh?
Public Enterprises Department, Your Lordship.
No. What is that? Assam, there's a ROP. What is this ROP known as? Assam Revised Pay Order. There's mention of it.
ROP.
ROP is known as some
Revision of it.
Revision of pay scale.
Revision of pay scale.
Revision of pay is ROP.
Yes.
Before that, there is one thing. लिख ले। Whereby the Assam Services bracket revision of pay bracket close, rules 2010 was extended to to the state level public enterprise with effect from 1/1/2011. It is the case of the petitioner hearing that the Assam Fisheries Development Corporation, in terms with the notification dated 7/6/2011, falls within the category C1. And the applicability of the Assam Services bracket R revision of pay bracket rules 2010 was brought was subject to the Assam Fisheries Development Corporation being audited up to 2009-10. It is the case of the petitioners that the audit to be done to the respondent corporation is not within the hands of the petitioners. And as such, because of the inaction on the part of the correspondent corporation to perform the required statutory audit, should not deprive the petitioners of their entitlement in terms with the Assam Services bracket revision of pay bracket rules 2010. On the other hand, Mr. P. Sharma, the learned counsel appearing on behalf of the respondent corporation, submits that the statutory audit of the respondent corporation has been duly done. And at present, the respondent corporation is paying in terms with the 7th pay commission. And as such, nothing survives in the instant restitution. Mr. A. Sulia, the learned counsel appearing on behalf of the finance department, submits that the Assam Service bracket revision of pay rules, pay bracket rules 2010 cannot be applied automatically. To public undertakings, such as the respondent corporation, submitted that in terms with rule 2D of the Assam Services bracket revision of pay bracket close rules 2010, the said extension can be made only by way of an express order by the governor, by the government, which have been done by the notification dated 7/6/2011. Upon hearing the learned counsels for the parties, this court does not find any infirmity in the notification dated 7/6/2011 by which the government of Assam had extended the benefit of the Assam Service Record Revision of Pay Rules 2010 to the employees of this Assam Fisheries Development Corporation along with other state-level public enterprises. Making it subject to the completion of the audit up to 2009-10. This court also has to take note of the fact that the respondent corporation also note of the fact and note of the submission of Mr. P. Sharma that at present the respondent corporation have been regularly performing its audit and have also and at present giving the seventh pay the benefits of the 7th pay commission to the employees of the AFDC of the respondent corporation. Taking into account the same, this court is of the opinion that nothing survives in the incident writ petition. Accordingly, the writ petition stands closed.
Item 8.
Yesterday, while going through the petition, I found that there are several documents.
Huh?
There are several documents annexed to the writ petition, my lord, which are not very legible and photos of its honorable court and everything. When I have asked for certified copies of the same, and could I be given 1 or 2 days time? And those orders I'll have to refer to. If lordship has page 58 for a moment, page 58, 56, my lord, these are not legible copies, and I.
Which is the impugn order?
Well, it is not the imperial. These are orders where similar benefit was granted to the other petitioners who are like the writ petitioner. These orders have to be read in full.
What are you asking for?
Well, we are asking for the pay scale, for a certain pay scale to be given to us, which has been denied to us only on the ground that none of the incumbents are diploma holders in that particular group. What has happened is, my lord, certain pay scales were when they were given by the pay commission, these pay scales were for the particular post. In most of those posts, they were either diploma holders, direct recruitees, or non-diploma promotees. This honorable court has held that both will be granted the same pay scale. That is how it's good. In our case, there are no direct recruitees to the post, although direct recruitment is allowed to the post. We are all promotees there. And the only reason we have not been given that updated pay scale is that there are no direct recruitees. And promotees do not have diplomas, and therefore they will not be entitled to get the pay scale.
But similarly situated diploma holders have been granted.
Diploma holders and non-diploma holders have been given that upgradation of fees. We are chargeman signal, chargeman mechanics, overseers, everybody where the post allows both diploma holders and non-diploma holders have been given the upgraded pay scale. In our case, that pay scale has then not been given by the department only on the ground that we do not have direct recruitee diploma holder holding any post. That kind of in our submission is when the pay scale is given for a particular post and application is given from one pay scale to another, mere absence of direct recruitees with diplomas, and now when they have brought in direct recruitees with diplomas, even they have also filed a case in the Delhi High Court saying that they are entitled to the upgraded pay scale.
But there are similar writ appeals Orders passed by this court?
My lord, yes, sir. Repetition orders have been, those orders are at page 54 onwards.
Huh?
Page 54 onwards. On page 54, we have given those orders.
Huh.
But lordship will find that those orders are not legible on the last, on the right hand side part of it.
By Justice B.K. Sharma?
My lord, yes, just these are all I had tried to search the net. These are not.
Are employees of Porter Road Organization under the Ministry of Shipping and Road Transport holding the post of charge mechanic. You are mechanic?
No, my lord. We are chargemen signal.
They were
We had the
initially
same
appointed
scale-
as vehicle
scale was
mechanic,
updated.
Yelter, Colonel, Point during month. They have been promoted to the post of mechanic, which post they have been presently holding. As per the, huh?
That is what these orders somewhere there are
Something is
I
missing.
need to bring this but corrected orders on record. Somewhere a page may be missing, somewhere the right hand side entirely is missing. I will not be comfortable with it. Just a day or two time that I have tried to look at that. Let me please better.
Star Majumdar, the learned counsel appearing on behalf of the petitioner submits that he may be granted some accommodation taking into account that the annexures to the petition are not legible. This court upon perusal of the petition also finds that some of the annexures are not legible. Considering the above, that the matter be listed immediately after the bifurcation. Mr. P. Chakraborty appears for the respondent.
Nine.
May I have it, my lord? The matter regarding my lord, removal from service. The husband of the petitioner was serving as constable in the CRPF. And in the year lordship 2013, the petitioner became ill and he was granted medical leave and also he was made treatment in the CRPF hospital. Thereafter,
Where is the other side? Nobody is there.
Lordship, K. Gopal is on left.
Who?
K. Gopal.
Then
lordship, in the meantime, my lord, the husband of the petitioner expired. She also, her claim was also to pay the service benefit and dues. That has been paid, my lord. The provident fund and insurance that has been paid. Only the now claim is that, my lord, whether she is entitled for pension because if the removal from service order is not set aside, she is not entitled for pension because, my lord,
what is the charge on which? it has
charge was
happened?
that, my lord, unauthorized absent, overstay, overstayed, my lord.
Overstaying, you have been removed.
Yes, my lord. Overstayed and the declared deserter.
Now, where is the question of overstay and deserter? Let us
Overstay,
see the memorandum.
lordship will find.
What is the allegation against you?
Allegation lordship will find memorandum of charge. at
Yes.
page
Yes, where?
I've been supplied only with the, my lord, inquiry report, page,
Huh?
inquiry report, page 27.
Page 27. You don't have the memorandum of charge?
No, my lord, that was not supplied, but they have annexed in the, their affidavit.
Well, understood. Without the memorandum of charge, how can you reply?
Yes, my lord, nothing, my lord, that was expired.
Okay, I so and so man appointed as inquiry officer to conduct the departmental inquiry by command. after this, order having been passed,
Yes.
the inquiry report, you were a government servant? Are you not a government?
No, no, no.
What? You're a military person.
Yes, my lord, government servant.
Government servant.
Ah.
Were you given an opportunity and the inquiry report was given? How did you get the hold of the inquiry? Where did you get this inquiry?
Lordship, that was sent to the home, my lord. He did not participate.
Where did you get the inquiry report?
Inquiry report that sent through messenger.
Huh?
They have sent it through messenger to the house of the petitioner.
So you were there in the house?
No, my lord, he was in the house, but he was hospitalized. He was from since 2013.
2013? Ah.
Since Lordship 12/9/2013, he was ill. And also there is also medical report in Lordship on page 20. Page 20 of the legal verification by the department, that is CRPF authority, that he was referred to the hospital. And page 22 is the medical verification report of my page 22. And in their affidavit, they have also admitted that he was ill and he was sent to the home for treatment. Rest for 1.5 months. Light duty after 20 months.
So why is this half of it? Where's the verification report?
Verification report. Report is not, my lord, supplied. And
Mr. Counsel, you want the help of this court. How will this court help you? Tell me.
No, Lordship, in their affidavit, they have connection.
My specific question is, how did you get the inquiry report?
Inquiry report, my lord, I've been supplied
By?
by special messenger.
How? With the inquiry report, were you given a show cause to reply as to why punishment should not be imposed?
No shock cause is there, my lord. That is the finding is there. Finding is there, my lord. That has already been proved. Finding is Lordship on page 32. Has summarily been proved beyond reasonable doubt, beyond any doubt. So after being proved by the inquiry officer,
Yes. Tell me.
My senior is supposed to appear today.
So what is your case, mister?
Case is that, my lord, it was a ex parte proceeding, my lord. No opportunity was provided, and as he was under medical treatment, he could not appear. That aspect was not considered, and total violation of principle of mental justice. He has served more than 16 years. May been given the retirement, voluntary retirement, or he may be discharged from service. So, my lord, the removal from service and this is the major penalty is not warranted.
So what is the charge against you?
Charge is absent, my lord.
Well,
Unauthorized
period,
absent.
period of
Unauthorized absent.
absence is,
The lordship will find memorandum is there, my lord.
I'm asking you, what is the period of absence? Mr. Das?
Period of absence is, my lord, say here it is mentioned that 70 days.
Huh?
Period of absence, the lordship will find from
Mr. Das, you are not prepared.
lordship, I'm saying.
You're not prepared. Mr. Das, you do one thing. You prepare yourself. One, you get the fact. Secondly, you find out, trace out if you can develop your argument with the Constitution Bench judgment in ECI. I think 92 or 93. The Constitution Bench judgment. Have a look. And can you develop your case on?
Yes.
Because you see, whether you were served a memorandum of charge or not, that is why I put you the question, how did you get the inquiry?
Memorandum is there, my lord. Lordship, I'm sorry, my lord. Page 25. Memorandum was served.
How did you get it?
The memorandum through special mail, through registered post.
When did you get it? Then why you are saying that no opportunity grant?
Memorandum was served, my lord, and also it is admitted that he was under treatment. That aspect was not considered.
So did you file a written statement of defense?
No, my lord, nothing has been filed, expert email.
Why? Why didn't you file it if you got your memorandum of charge?
On the ground of medical ground, my lord, it is there on medical ground. It could not appear.
Did you bring to the attention of the inquiry officer or the disciplinary authority that look here, that I am not in a position to submit the memorandum, the written statement of defense because of my illness? Have you mentioned it anything to the effect?
No, my lord, that is not.
Then how can I help you? Tell me. Why you are saying that the principles of negligence justice has been violated?
My only case is that, my lord. My only case is that, my lord, the department should consider his not intentional willful absent, my lord. That aspect has not been considered. And
Why will the department consider that when you have not represented this? And why should this court look into that? Did you file an appeal?
No, my lord, appeal was not.
Why haven't you filed an appeal? This court can only look into it if there is a violation of the constitutional rights.
Yes, my lord, only if the constitutional right.
Then how can I decide this without you helping me out?
My lord, 7 days time may be granted, my lord.
What 7 days? You know this matter can't happen after reunification. Not Mr. Esdas, the learned counsel appearing on behalf.
That's not, my lord. That's not.
As
Not.
learned counsel appearing on behalf. Request for an accommodation. You lack reach. That good.
Obliged. If your lordship will kindly note, the down below in the service book, my lord, there is a note, my lord. The entries of this page should be renewed and retested for at least it should be every 5 years, and the signatures in 10 and 11 should be done.
And the signatures in line 10 and 11.
10 and 11 is the signature of the employee, my lord.
Take it.
Employee and the head.
Yes, 10 and 11 it is there.
10 and 11 it is there. Surprising is, my lord, because the other service book, similar in a writ petition which was withdrawn, where my learned friend was a petitioner, in that service book, the date of birth is there.
Oh, this is
We
Prakash
are
Dekha.
only concerned with
Yes.
here to one Bahul Islam.
Yes, sir. That is Prakash Dekha. Your lordship suggested me, my lord, that if yet no formal order is passed for recovery like that case, my lord. So, my lord, I withdrew this petition and waiting for any formal recovery order like that.
So you allowed him to work till 2021.
Yes, sir.
You want to recover it from the block development of it. What do you say? That is why the Advocate General was summoned. I've asked him to come.
In fact, we have briefed the secretary of the department also that the circular has to be issued, because
No, I think
otherwise, my lord, the rule
I think I will
94,
put it out there, okay, in this
yes,
order.
that will, my lord,
I think that is necessary, because that day I was coming across, there is a office memorandum of Ajay Chaudhary also. Everywhere there is. So,
yes.
in fact, in this Rafed Ali also, you need to bring it by way of some office memorandum.
Yes.
Because if they don't do
That
it,
also I pointed out.
because what is otherwise happening? Because I got another case, which needs to be further looked into. As you were doing this Rafed Ali and all this, your matters is also. The Ajay Chaudhary judgment does not take into account what will happen if a memorandum of charge is not received. That day I came across a map where the petitioner is not willing now to receive. Now what to do then? Can you say that because the basic of the principle is an early resolution to the departmental proceeding
has to be done. That is basically the intent of the.
And that is the reason why it has been made.
Yes.
Although if you respect the Supreme Court had drawn a simile with 167.2. But what will happen when a person does not receive the memo? Can you still say that no, you have to do it? Because the word is served.
Served.
Now, if you can't serve it, in spite of whatever attempts you are taking, then what to do?
In a judicial
another
proceeding,
thing
it
is-
can be, though in a judicial proceeding, my lord, the deemed service concept is there, but that whether it will be applicable in an administrative action, because if it is issued to the correct address,
No, here he is not receiving in that case.
is refusing to.
He directs it.
Yeah.
Even during the court, I said, kindly receive it. He says, no, let them serve. If that be so,
yes,
then how do you take care? You can't have it in that manner. Because the basic idea behind that is early completion.
Yes, there should not be a prolonged suspension.
And if you want it, you don't want to receive the memorandum and start the departmental proceeding,
Well,
then otherwise there might be a case where lot of time has gone. You are not being, and another very important thing is nobody takes note of paragraph 22. In Ajay Chaudhary, paragraph 22 is very relevant. Wherein it says that this shall not apply now. Because of the fact that this person concerned, the memorandum of charge has been given.
In that particular given case. Yes.
So then, if that be so, when a memorandum of charge is being given during the pendency also, can you say that still you can apply it before? Well, I think I'll pass the order.
Yes.
The other matter is in connection.
No. Rafiq must have done it.
In other matter, my lord, it is old, my lord. Otherwise, first that one, my lord, second one is there, my lord. This impugn order is challenged. Your lordship earlier asked me, my lord, whether it is challenged. Then I said, my lord, it is challenged in this petition. Therefore, it is taken.
The learned counsel appearing involved here.
Yes, sir.
The learned counsel appearing on behalf of the petitioner, Mr. B. Kaushik, represents the elementary education department. Upon hearing the matter at length, the judgment is reserved. And hearing completed, judgment reserved. The learned counsel appearing on behalf of the elementary education department have produced the service book of the petitioner. The court officer, the pension system is directed to make photocopy of the same and return the original to Mr. B. Kaushik. Make photocopies and keep a copy of the same in the records, and the original be returned to Mr. B. Kaushik.
But one IA is there, my lord. That may be not present. Otherwise,
I am for the phone number 4.
SR Borua appears for the director of pension.
One judgment which I came across, my lord, of our High Court, my lord, on this issue. My lord, I was looking for it. I kept in my file. Of Justice Manojit Bhuya. My lord, I'll produce that, my lord. There was an indication if there is a misrepresentation with regard to the overstatement.
it is always there.
Because otherwise, my lord,
problem
right
is
from
this.
Jagdish Prasad and your lordship's
Whatever
judgment.
may be, but the problem is you see the other judgment, not 2022. What is that English name? Daniel
Thomas.
Daniel
Yeah.
Thomas. There,
Para 9 of that.
but although para 9 is there,
But it again followed
in the
your-
penultimate paragraph, one thing is made clear that there is no allegation of fraud or
fraud and
misrepresentation.
misrepresentation.
So unless you do that, which is one of the most difficult things, which you
Yes.
can't do it.
Yes.
If you do that, then obviously this court
Obviously.
may say,
And my lord, with all respect, my lord, I have annexed already at one judgment, your lordship, page 58. My lord, there, my lord, Supreme Court gone to that extent, my lord, that even fraud is there, but state has not taken any action, my lord. In the belated stage, my lord, they cannot tell it.
what judgment is that?
My lord, this is my lord 1994.
No, that law has thereafter been changed with the Jagadishwar Prasad.
Jagdish Prasad Pandit.
This takes care of that. Wherein earlier there was the Supreme Court had made it clear that once you avail the service, there is no question of not paying or overstay doesn't. Then a matter came up in Jagadishwar Prasad to that effect, and that very judgment was taken in Jagadishwar Prasad at paragraph number 24. This aspect. And thereafter came other judgments whereby there has been a big change, but it is only in Jagdev,
Jagdev Singh.
Huh?
Jagdev Singh.
Jagdev Singh. Jagdev Singh is the case wherein the first time it has been brought in that when you are put to notice, but that is on pay fixation.
Yes, pay fixation.
And it has been increased, then you have to pay.
Here in this case, my lord, my instructions.
In all those judgments, Jagdish Prasad, your lordship's judgment in Nilotpur Prasad, well,
there is a change in the facts, my lord, because there was a default on the part of the authorities itself in mentioning the date of birth.
Now, in Nilufar Islam, if I remember correctly, the date of birth was put as per the petition.
As per the petition.
But later on, at a later stage, it was found that the certificate which was by the Director of Pension or the Accountant General, it was found that okay, this is the state of affairs. As per the date of birth which was mentioned in the certificate AHSC6 subject, well, that certificate, then in that certificate, it was mentioned that it was 2 years before.
Yes.
But it was at the time of her appointment on the basis of an affidavit. This was
That was nothing.
Overstay by heart.
But here, my lord, my humble submission and instruction is that, my lord, I requested to release me, my lord. What is there, my lord? At my instance, ultimately, they might release me, my lord. By
Mr. Borbhuye, the matter is going in your favor. Don't worry. I'm only making it CAV because of the fact that today the court has a constraint.
My lord.
We are rising today early at 15.
Almost 12 to 30.
Yes.
Lordship, I'm not that fully prepared, but I'll try to assist Lordship as much.
No, matter is simple. We'll go into other aspects. What is your ground on in your appeal, which has been filed against the assessment of? What is your ground of appeal?
Ground of appeal is only on the basis of addition. There we cannot say in appeal we cannot challenge certain seizure procedures. In appeal we cannot challenge certain seizure.
Understood. But what is your ground in appeal?
In appeal, the wrong addition that they did, for that we went.
Why? Why the wrong additions were made? What is your ground for that?
Lordship, actually the appeal has been filed by some other council, the law authority. I don't have.
You had the time from yesterday. You have the order.
Lordship, I received the order at 12 o'clock. I sent through email, Lordship. It's about 600 pages.
600 or 1,000 pages doesn't make a difference.
No, I could not take out print because I received it at 12 o'clock.
So Lordship, and what happens, we also tried, what happened because it is so, it's in the portal, but when I tried to download it, it could not be done and printout could not be taken, Lordship. Otherwise, it could be done. I tried it.
No,
it's on the portal itself. And they have
I can read
applied
out the
for a copy.
operative part.
Yes, read it.
In view of the aforesaid discussion, respectfully following the judicial pronouncement in according with the settled law, and specifically in the light of the binding decision of the honorable courts and ITAT in case of so and so. In the pronouncement of the cited reported above principle of judicial discipline as disallowed the addition of rupees 3 crore 91 lakhs so and so made by the assisting officer in this case hereby deleted.
Why?
But if there are some judgments that reflected from some binding judgments are there that were not considered by the assisting officer.
No. Binding judgments for what? Only for the
Regarding
purpose. Wait, there might be two others. One is a case of addition being made, which is divorced, certain binding judgment. One is an addition being made on the basis of an illegal search and seizure. And when there is an illegal search and seizure, on the basis of those judgments in pertaining to illegal search and seizure, the court says that yes, the search and seizure is bad and as such time bound.
No,
Yes, what is this? One order I've got it.
This
Wait.
is the tribunal order, Lordship, in the following which this order has been passed.
Okay, let us see. The ground raised by the revenue.
Ground, Lordship, paragraph
No,
13 and
paragraph
14.
3 is what? Who has filed the appeal?
Some other party, Lordship. This has been followed in this judgment, Lordship, which has been passed in my case.
This has been followed.
This has been followed. That Rohit Jain and Rashmi Jain, what
Both
is
the representatives of the revenue and
paragraph 13 and 14, Lordship.
Yes, what is the
Lordship,
judgment?
this is a judgment of constitutional bench where it says that even if search and seizure is held to be illegal, the materials collected during that that can be relied on. Paragraph 20. Lord. And it is a open page.
So we'll hear on merits then.
Then I'll produce the record. Lord.
Okay, let us hear on merits. Yes, madam, tell me. So we give up the question of infraction. Yes, why are we challenging it?
Yes, Your Lordship, with all these matters, except two matters, that is today's list, item number 16 and 17 is little different in fact, rest all are same. In these cases, Lordship, what happened? In the 2000, in the year 2000, there was a search conducted in the premises of this all jewelers. Now what happened when they conducted this?
You are saying the difference is it 4176?
Difference is in, no, not in this, Lordship.
This is same for others.
Yes, all
Okay.
other, only item number 16 and 17.
16, 17.
It is little different.
Yes, tell me.
Lord, a search and seizure was conducted in the year 2000. After that, they tried to transfer those the jurisdiction from Dibrugarh to Kolkata jurisdiction by an order dated 18/7/2000. Then a case was filed in the High Court. High Court stayed the order, not giving the transfer. So what they did is they passed the, since there was a state, the assessing authorities in Dibrugarh, they did the assessment in 2001. Now, this, since the assessments were already completed, so the department they issued a retransfer order in the year 2007 when everything was over, giving it effect from 2001. So that was over, that search and seizure is over, and all the assessment, it was nothing was found, and it was same assessment. What return we have filed, there was nil assessment. That was done. Then in 2015, again they conducted a search in the premise, and in that search, they covered the assessment periods from 10/11 to 16/17, Lordship.
10/11 to 16. So they can do for 6 years if I'm not.
Yes, for 6 years. So till 16,
From the date of which it is
search
search and seizure is done.
Previous 6 years. Previous 6 years they did. So 10/11 to 16/17 they conducted the search, and in this case also they chose manually 16/17 as the scrutiny period. For that assessment they picked up the thing, and they were doing the scrutiny assessment was going on, and 153A notice was given to file the returns again. So they filed the return and the procedure was going on. And in the meantime, when this process was going on, then in 2017, after coming of GST, they again conducted the third search.
Another search.
Another search. That is the search we are in. We have come before this court.
In 2017.
17. So in that search, which periods they want to cover? Because 10/11 to 16/17 was already.
Why you are challenging one in 2017 search?
Yes, yes.
Why?
Because again they want to transfer the cases to Kolkata. Lordship, that Lordship will find.
Why? No, the illegality of the search is challenged. Why?
Because there was no reason to believe why.
So your basic ground is the search and seizure requires a condition precedent to have a reasons to believe.
Reason to believe.
And the reason to believe has to be based upon certain
valid document and valid findings.
Which was not there.
Which was not there.
So you are challenging this.
Yes.
Okay.
And
Now,
and it covers also the same period. That also they cannot. Lordship, when 60.
You see, first 2000 they have done.
Yes.
Then in 2015 they have done.
2000 they have done for the block period 89 to 99. That was over.
Okay.
Then again in 2015 they covered the period from 10/11 to 16/17.
2015?
When they conducted the search, that covered the period for 10/11 to 16/17.
How? 16/17?
16/17 also they took as a manually they have taken 16/17 as a period.
But can it be done? It has to be prior
to that.
2015.
Yes, till 2000.
Then
Again 2017 search was done. In that 2017 search, which period they want to cover? The period that they will cover.
so whether they do it in the what period, that is their lookout. We are not concerned. That is another aspect to the matter. But the challenge to the search has to be
preceded with reasons to believe.
please.
There was no reasons to believe, Lordship,
So your entire case for challenging the search and seizure is that there is no reasons to believe.
there's no reasons to believe, and they again want, because once they tried to transfer the cases, that was stayed by this court.
Hmm.
So my jurisdiction was with Dibrugarh. So then second search, again, Dibrugarh officers were doing the assessment. Again, after this search in 2017, they again wanted to transfer the cases to Kolkata.
That is another aspect, madam. That is, they want to, that is different, but the reason for challenge of the search and seizure,
Yes.
as I
main
could
reason
see, is
had
that
no
they
reason.
didn't have the reasons to believe.
Yes, they
The
had-
search and seizure is done under 132.
Yes.
Let us see, income tax act. Oh, look, what else is in that? We are otherwise a suspension court. Suspension and pension court. So, yes, there is a book. One 32. By the principal director of
There are three conditions, Lordship, A, B, and C. The first two conditions doesn't.
any person is in possession of money. You are into 3. C.
Yes, Your Lord.
Any person in possession. So you have done under 132C.
No, they did not say any reason till now because
No,
they
no,
didn't
let
file
us
their petition.
ask you. You did it under 132C or 132A or B.
What's actually record is not.
What?
Present.
Dr. Gogoi, done under 132B or C or A.
Lordship, in petition number 4149, affidavit has been filed.
Yes, what is it?
132, 1B.
132?
132B.
B.
132, 1B.
Paragraph 11.
132 1B.
Lord.
Oh, he's not on C.
B.
Any person, Lordship, is
Any
on B.
person whom the
To
summons.
Any
whom a
person to
summon or
whom
notice
summon-
as aforesaid has been or might
might
have
be
been issued will not, could not, use or cause to have been produced any document will be useful for or benefit any. So the condition precedent out here is that there has to be issuance of a summons or notice.
and they have the reason to believe that I will not.
The reasons to believe
That I will not.
that
produce.
any person to whom a summon or notice as aforesaid has been or might be issued will not or would not produce. So somebody who have been issued or may not have been issued, but there is a reason to believe that he would not produce.
Yes. But in my case, this will not apply, Lordship, because my proceedings were going on.
Any books of accounts or documents with so that narrows our now what is the basis you have done? What are the documents you sought for in respect to which year? did they take steps on the 153A here also?
Yes,
Yes.
they asked us to
Yes, sir.
produce, file the return, and we have filed the return. On that basis.
Now, if that be so, they asked you to file your returns from another, again, 6 years back,
Yes, 10/11 to 16/7.
as per the, after this search.
Yes. Again, the same period. In 2015, whichever periods they asked me to file under 153, the same period they want me to file in 2017. 2017, they did not issue a notice at all, Lordship. They only wanted to transfer. That stage did not come only. Before that, we filed the petition and they did not take any steps. But they have no assessment years in their hand for which they can ask for.
Yes.
Lordship, affidavit is filed in this case, paragraph 5.
Lordship, they filed the affidavit. They gave me a copy just now, but I received it.
Item 26. Before that, Lordship, may one present judgment of Supreme Court passed on 13/7/2022.
Which one?
I'm fixing the copy. Lordship,
What is the
paragraph-
judgment for?
Paragraph 33 with regard to search and seizure.
Ah.
One guideline has been put by the Honorable Supreme Court how it to be made, and probably
No. Okay. Starting from Calcutta discount, the law has been very clear. You have to have the reasons to be. Now, if we come under the concept of 132(1)(b),
Sure.
you have two reasons to believe that if this document you have asked him, or if you had asked him, he would not produce. And as such, you have gone for such.
Sure.
The matter is, now, you see, why should we, this court further extend the parameters of the or the contours of this petition beyond? The learned counsel for the petitioners only remains out here is that there was no reasons to believe.
Yes,
and as such, we limit ourselves only to that. What happens thereafter, whether the pursuant to the search, if any assessment has been done or not, this is for the appeal or the authorities to decide.
Yes, sir.
But the fact that search and seizure, if it is illegal, cannot be challenged in the proceedings under the Income Tax Act. That is why she has initiated the proceedings under 220.
Lordship, there is this probably this will help our
Yeah, let us read it.
paragraph 33. I'm giving the copy of it. Paragraph 33 of this judgment. Here also affidavit paragraph 5, 6, and 7, 8.
What are these judgments for?
This is the with regard to search and seizure.
What is it?
Paragraph 33, Lord.
Would like to restate and elaborate the principles in exercising this jurisdiction in matter of search and seizure. The formation of an opinion in the reasons to believe recorded is not a judicial of possibility. Must be in possession of right. It cannot be an evidence constitution of extraneous or irrelevant 4 is money billion. We are not concerned. We are only concerned with 3.
Yes.
The 3 says the authority must have information in its possession on the basis of which a reasons to believe,
Yes.
a reasonable belief can be found that the person concerned had omitted or failed to produce books of the accounts or other documents for production of which summons or notice have been issued, or such person will not produce such books of account or other documents if summons are issued.
Yes.
These are the two. That is the only thing. Such reasons have to be put up in the event. In which such yes. And these petitions were filed in 2020.
20.
And why haven't you filed your affidavit till now?
What's it,
We are
180?
relying upon a judgment of the Supreme Court, wherein we say that such reasons may have to be placed before the High Court in the event of a challenge to the formation of belief. The competent authority in which event the High Court would be entitled to examine the reasons for the formation of the belief. How did this court examine if you don't place?
What's it, I will produce the original record. Any day, Lordship, 180.
Let us see what is your reason. That is why I say, no, we'll see the law. Although I have not done income tax matters for a long time, but that also the fundamentals are there to that only to that effect. Let us see what is your reason on why you think that a petitioner, even if being put to notice, or even no notice is being given, also the petitioner is not going to give these documents. Why do you think that?
What's it, paragraph 10 and 11?
In response to demand, the deponent strongly denied since it is a matter of record in the circumstance under which the search seizure can be conducted is that the authorized who is the report has in his possession to which he has reasons to believe that stated here that it is satisfied with the search. It's legal has I hope you have looked into the affidavit before filing it.
was filed.
You have said many things. But the prime aspect which needs to be said out here is as to whether
That is not
there
there.
was a reasons to be.
That is not there.
You are saying it is not required to be intimated.
Yes.
No doubt, the law is very clear. It is not required to be intimated. But the question involves out here, you have said that in 2015 there has been a search and seizure, and
Yes.
pursuant to that you have gone ahead with a assessment proceedings and now. But for completion of that, you require. But what do you require? What have you not got for which you could not? Either you have to issue notice or notice for what? Only for the books of documents, books of accounts, or any other document which you have reasons to believe has been withheld. So there has to be some document.
It must be.
You can't make a fishing and roving.
No,
and
that cannot be. It is not permissible on law.
so in view of 136B, or 132, 1B, it's clear to the effect that it has to be only on the basis of those documents which you require for completing your assessment, which the petitioner, even if put to notice or even without notice, is not going to put. But you must be knowing which are the documents.
That probably I'll produce the original record for perusal of the law. So that will solve the entire.
And by that time, you will be able to download the 600-page order.
That I'll. Let's say there are 9 appeals.
Huh?
There are 9 appeals of this group.
9 appeal or 10 appeal. You see the reason why I'm saying it.
Lordship, I got.
If we see the order which you have read and the order which Madam has produced out here, shows another aspect. First was the aspect as regards abatement under 153A in respect of certain proceedings. So what happens if the moment there is a search and seizure and there is a notice issued under 153A, all pending proceedings of assessment stands abated. So that is one aspect of the matter which have been taken note. The second is as regards incriminating materials which was found.
Collected.
And in this judgment which she has produced out here, the CIT appeals had categorically observed that there was no incriminating materials to it, and under such circumstances had disallowed the additions. And the appeal and the revenue board, I think the appellate, this income tax appellate authority, the tribunal, have affirmed it to that effect. Now, if it is here the case that the assessments were done in respect of certain abatements which has happened, or the Commissioner of Income Tax Appeals have come to a finding that look at there is no incriminating materials out there, it is different.
I've gone to the operative part of the appellate order, where it is, says that some binding judgments with regard to addition were not followed. So
This is the judgment which she has produced.
So these judgments were referred to, and that's why this deletion was.
So that has been whatever may be. But the search and seizure upon that, search, because to make it infructuous, which you have mentioned out there, to make a particular document or particular search and seizure incident proceedings as infructuous on the basis of the search and seizure, and there has been certain additions which have been set aside. If it was based on that, it is a difference. Because tomorrow, as you said, the revenue is considering of filing a further appeal to the tribunal. Whether they would get a scope to argue on the question of this illegal search and seizure.
Probably it will be not be allowed well in appeal law.
If that is not allowed, then if I foreclose the petition now, putting as infructuous because of that, it would be.
Then
so we'll look into the aspect as regards whether you satisfy 132.
I'll produce the entire record, Lordship. That will be. And with regard to Lordship.
Lordship, for a moment, Lordship will kindly come to page 83 of this petition, 4176. Page 83 of 4176.
Which petition? 4176.
The first petition, Lordship, item 12.
83.
Page 80.
Nah,
This is the group assessment lordship, group assessment order, Nemichand, Kamalva and Sons. They are all part of this group lordship. Lordship, I'll read from paragraph 2, lordship.
Hmm.
A search and seizure operation was conducted at the business premises of so-and-so on 3/9/2015 in pursuant to warrants of authorization issued by the Director of Income Tax Investigation, NER, Guwahati. The search was concluded on 18/9/2015. In the search operation, following premises were covered under section 132 and 133A of the Act. These are the premises, whatever they have covered, lordship. Lordship will kindly come to paragraph 3. This is of importance, lordship. Consequential warrant or under section 132 of the Act was issued to operate bank lockers which were kept under prohibitory order under section 132(3) of the Act, following are the list of locker details. Lordship, this has happened on 18/9/2017. That means after 2015, when they were doing assessment, they wanted some more inquiry. So this consequential order of warrant was given and a search was done. After this comes the third, which I am talking about. We have challenged here, page 91, lordship. That is 2011-2017. Alert paragraph 5 also is there. That is the details.
This paragraph kindly come to paragraph
Paragraph
5.
5. Yes, there they say that they have represented themselves also.
Was
Lordship,
issued and
paragraph 5.
duly served upon
Consequent
the
to
SSC for the relevant assessment year.
consequent to search and
In-
seizure operation, may I
in-
read, Lord?
Yes, search.
Consequent to search and seizure operation held as discussed above, the return of income filed for assessment year 16-17 of the SSC firm was manually selected under compulsory scrutiny category as per CPTT's instruction number so and so 7th July 2017 and notice under section 153A dated 11/5/2016 was issued to SSC calling for return for the assessment years 15-16, 14-15, 13-14, 12-13, 11-12, and 10 and 11. In response to the notice under 153A, the SSC filed return of income for the assessment year 10-11 on 13/9/2017. Accordingly, notice under 143(2) of the Act was issued and duly served. Likewise, notice under 41(2) of 142(1) of the Act, along with detailed questionnaire dated 3/10/2017, was issued and duly served upon the SSC for the relevant assessment year. In response to the notices issued, Sri so-and-so FCA, Sri Basant Sharma, representative of the SSC, appeared from time to time along with books of accounts and other required records, documents, and details. All the books of accounts and documents furnished by the learned AR were test checked and examined with the ITR and other statement of accounts. Appraisal report of the group prepared by the DIT investigation Dibrugarh is perused and it is seen there is no specific information in respect of the SSC related to the concerned year in the said report. However, all necessary test check of accounts and relevant documents were carried for verification of return of income filed for the assessment year 10-11.
After due examination and necessary verification, income of the assessee for the assessment year 10-11 is assessed as per returned income. So there
So
was
pursuant to the assessment, pursuant to the search made in 2015, they have issued a notice and pursuant to that, they have made assessments.
Yes.
So therefore you say that where is the reasons to believe?
where is the reasons to believe? And they, in page 91, Lordship, they punched some other
Or is it an action taken by them by making a search to reopen a assessment?
completed assessment. Maybe they want to do that. I am not.
No,
Because they
it
have not
seems,
said.
it
Yes.
seems, which they may not like to do, otherwise, means they ought to have gone into the field of reassessment, 148, huh?
Yes, 140.
148. 148.
Oh, yeah, 140. So 148, they should have done it, but instead of doing that, they are again made a search for the purpose of doing.
Yes, this search was, subsequent search was dated, it is, subsequent search was again on this 17 only, Lordship. Subsequent search was made. So that.
Now,
they could-
understood? No, this is made on the basis of the search. And you see, this search is after the 2015
Yes,
and the 2017 on 18/9.
no, 2017 to search, that's what I want to show. to your
18/9, na?
Yes, Your Lordship. This is a consequential search they did when they were doing the assessment. They thought some things might have missed. So they searched again, they took out a warrant and they searched and they completed the assessment. After this, immediately after this, again
They
in
issued notice to you.
2011, 2017, again they do a search.
This is after the completion of this order. When was this order passed?
This order was passed, this order date, that is what, Lordship, I was searching the date, Lordship, I could not. It must be in 2017, 8/12, because the demand notice is there before that. Lordship, page 82. 8/12.
Are you challenging this? No, no.
No, we are not challenging. We are
You are
challenging
okay
the,
with this?
yes, we are okay with the assessments. This has been completed.
This was done as
This was
per the page 82. This was issued on 8/12/2017.
17. Now,
And
Lordship,
when was this order passed actually? The assessment order?
assessment order date, I think along with the notice of demand, this assessment was served.
No, then why did they
The
go
order
for
date
an
is there.
assessment?
Lordship, page 83, order date is there, 8/12/2017. Lordship will find last line.
No,
the
no,
items
that I
11.
have seen it.
Yes.
See, this notice of this demand will come after the assessment being made.
Yes, same date they have served.
Understood?
Yes.
Then what was the necessity for going ahead with a search
On 2011.
2011?
Yes.
For what other purpose? Because here they require it for
Lockers.
which will be useful or relevant to any proceedings under the Income Tax Act. So there has to be a necessity for something. What is the necessity? Because you see, you have done the search on 2011, 2017.
Yes, sir.
And in the meantime, you have passed the notice of demand. The assessment was done and notice of demand was issued. If you have done this, what is the meaning of doing a search just what do you call 10, 17 days before? It makes no sense. Same case in others also.
Yes, all the.
So you get your point, which is however not clearly spelled out in your affidavit. It's a sorry state of affairs.
In one affidavit.
And Lordship, one more thing, they are telling that in 2020 we have filed the cases. That is not true. 2018, some cases has been filed in 18, 19, then in 20. Slowly, so many cases, so slowly.
We'll ask them to produce the records. But you get the point where what is the necessity? You have to find out because the assessing officer had given them notice, they produce everything, and then for what other purpose do you require? Reassessment will be done by whom?
Assessing officer.
And there is another thing, na, reopening, what do you call? Sumoto revision, what is that? Section
Section 236.
236. So that when the assessment proceedings was going on and the assessing officer had no requirement, how did you have a requirement? Or the persons had the requirement? You get the point, Mr. Gogoi, Dr. Gogoi? The affidavit is for a state of affairs. Chalo, we'll have it well.
That's it, because 31st March, all officers are with the ending of the year. It will be in the first week or after Bihu, just after opening of the Bihu lot. 20th April.
We'll have it on 20 April.
Lot.
Hermits M.L. Gupte, the learned counsel appearing on behalf of the petitioner. And Mr. H.C. Kyle, the learned counsel appearing on behalf of the Income Tax Department, along with Mr. Dr. B.N. Gogoi. The matter has been heard at length, taking into account that there is a challenge to the search and seizure proceeding on the ground that the condition precedent for exercise of powers under section 132 was absent. The learned counsel for the Income Tax Department is directed to produce the records. In the meantime, by 12th of April, the respondents are at liberty to file such additional affidavits, are given the liberty to file their affidavits in all the cases. Are the SSCs different
Yes, sir.
or different?
There are 9 groups.
Some are HUF also. Under them, those.
No, but then also SSCs are different.
SSCs are different.
So obviously,
Belong to same family.
are at liberty to file their affidavits in respect to the other petition where the affidavit has not been listed out. And in the meantime, find out your 600-page thing.
No, then I'll put it.
Lordship has heard it length, so it may be
Okay, let the matter be taken up for further consideration on
20th. 20th of April.
28th of April. Get your records.
Yes, sir.
Take on affidavit for the movement.